Yeah, this case is a year old, and we're having a misunderstanding of this hearing. Come on, that's not acceptable. Who is? What's your name, man?
Jason Hall.
Jasmine Hall. It's frozen. What's going on?
I could only get one of them.
24 CR 81 is now called. Jasmine Sade Hall,
Yes, Your Honor.
and you were here with Mr. Kindler, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment? Can we proceed in summary?
She's right there, Your Honor.
In summary, paragraph 1 of the indictment alleges that on or about November 21st, 2023 in Jefferson County, Texas, you committed theft, and any theft, even if it's a pack of gum, if you have 2 or more prior theft convictions in a county court at law or a district court of thefts, then it is a state jail felony at least. And you have, according to this, a 2011 in paragraph 2, 2011 county court at law conviction of Jefferson County, Texas, theft. 2012 county court at law 3, Jefferson County theft conviction. February 9th, 2015, Harris County number 10 criminal court at law theft conviction. November 18th, 2016, the 180th District Court of Harris County conviction of theft. August 10th of 2020, the 263rd District Court of Harris County theft. And finally, 2021 in this criminal district court, you were convicted of theft. So that's 1, 2, 3, 4, 5, 6 prior theft convictions.
I'm embarrassed.
You ought to be, if that's true. Yeah, well, you shouldn't be shocked. I mean, these are courts that should make an impact in your life. It ought to be something important to you. The fact that that you're acting amazed that you have these prior convictions, that there's no reason to suspect that these aren't true and valid. Don't act surprised. This is your life. You should know more about your life than anyone else. Anyway, you're looking at no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, Your Honor.
An agreement's been reached. In your case, you would be pleading guilty, placed on deferred or unadjudicated probation, fined $500. Is there any restitution?
There's no restitution, Your Honor.
Looks like another case pending would be dismissed
It's her misdemeanor.
in another court. So if you're placed on deferred or unadjudicated probation, that can be up to 5 years in length. There would be terms and conditions of probation that you must follow, and I'll put you on some kind of a theft program, commission of theft, but a theft prevention that we have with the probation office. So how do you plead here to paragraph 1, committing theft on or about November 21st, 2023 in Jefferson County, Texas, guilty or not guilty?
I'm guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, Your Honor.
And paragraph 2, those prior convictions that are here that we talked to you about out of Jefferson County and Harris County courts, are those theft convictions all true and correct as they are alleged in paragraph 2 of the indictment? And are you pleading true and correct to that voluntarily?
Yes, Your Honor. Oh,
Before.
I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney, or the contents all true and correct?
Yes, Your Honor.
State's Exhibit 1 is tendered into evidence without objection.
Without objection.
It's admitted. Among other things, the state you are mentally competent to enter your guilty plea and the plea of truth here to this state jail felony voluntarily. You were doing this voluntarily, knowingly, intelligently. You understand and appreciate the consequences of pleading guilty in this offense. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God.
Yes, Your Honor.
State's Exhibit 1, made a part of the record for all purposes. Pre-sentence report is filed.
So like,
I'm going to follow this agreement if nothing further and find you were pleading guilty today and true to paragraphs 1 and 2 respectively that constitute the state jail felony of theft. You were doing this voluntarily, knowingly, and intelligently. There's sufficient evidence supporting your guilty plea. And State's Exhibit 1 admitted here in this hearing. to find you guilty beyond a reasonable doubt of the state jail felony of theft. But I'm not going to find you guilty. I'm going to defer any finding of guilty, place you on deferred and unadjudicated probation for 5 years. You get a second chance, make the most of it. You're going to be required to complete, among other things, a theft prevention program that it's very helpful. And probationers do real well after they take that. There will be other terms and conditions of probation. Make sure you follow those. Also, you're going to be fined $500. Is there any restitution?
No, Your Honor.
And there will be other terms and conditions of probation, which are normal and customary for this. Make sure you follow them. If you fail, your probation can be revoked, could be found guilty, and sentenced up to 2 years in the state jail. We don't want that. Okay? Give it your best shot.
Did you want to say something?
No, sir, you have to be back.
Oh, okay. Okay. There's another case and it looks like that's going to get
There's the
dismissed.
sentence in the rows out.
Great. Okay. Please see the probation office. Yes. Thank you. Okay. Yeah, it's not on the docket. Thank you. All right, we now call Richard Gill.
Yes, sir.
That's you, sir?
Yes, sir.
In 24 CR 1240, you were here with your attorney, Mr. Dusler, and the state's attorney. There is a first amended motion to revoke probation filed as of May 21st, 2025. In this case, are you familiar with it?
Yes, sir.
Awesome. Are we ready to proceed?
Yeah.
Mr. Dusler, on his behalf. Raise your right hand, sir. Do you solemnly swear or affirm any statements that you're going to be making during this hearing shall be the truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. Can we proceed in summary? Does he waive a formal reading of this?
Yes.
In summary, sir, this first amended motion to revoke probation states that on October 7th, 2024, in this criminal district court, that you were sentenced to 10 years in prison, and that was suspended and probated for 10 years for the state jail felony of unauthorized use of a motor vehicle. Is all of that true, sir? 8 states that you committed the offense of failing to ID as a fugitive with intent to give false information on or about May 2nd, 2025 in Jefferson County, Texas, which is in violation of condition 1 of your probation order, which states commit no offense against the laws of this state or any other state of the United States. Do you understand what this charges you with?
Yes, sir.
Is this true or untrue? Are you pleading true voluntarily, knowingly, intelligently, and because it is true as it is alleged? Do you understand that a voluntary and knowingly made plea is true to 1 or more violations of probation? That's all it takes to revoke your probation. Your probation can be now revoked and you can be sentenced to no less than 2 nor more than 10 years in prison. Do you understand?
Yes, sir.
Knowing that, you insist on pleading true today to this violation.
Yes.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. Is there any need to
No,
plead
sir.
anything else? All right, stand by. So originally you entered your plea and were sentenced. This was a state jail felony of unauthorized use of a motor vehicle. However, you pleaded true back last October in this court when we placed you on probation to 2 other state jail felonies of theft prior convictions in 2023. So thus, that's why this is called a state jail felony, but it was punished because of those prior convictions as though it were a 3rd degree felony. You understand?
Yes.
Okay. So that's why you're facing no less than 2, no more than 10 years confinement in prison for this, even though we're calling it a state jail felony because of the 2 other prior felony convictions that enhanced or raised the punishment level here. All right. There is no agreement.
Correct.
Go ahead. For the defense.
Well, Your Honor, asking the court to hold this matter in abeyance and continue on probation. This new offense occurred, which stopped on suspicion of possession of drugs. He made a mistake by giving.
I've got it. Yes, ma'am. Sorry.
He realizes that he made a mistake by giving false identifying information, realized that was not a smart thing to
Thank you,
do
Ms. Fair.
at the time. But he feels like he can successfully complete his probation. We're not showing anything really, really bad right now. He's currently trying to rehabilitate himself from drug and alcohol use. It feels like with continued supervision from the probation department that he can successfully complete his probation. Is that correct, sir?
Yes, sir.
Is there anything else that I've not said that you want to add for the judge?
Well, Your Honor, if I would go to get some help.
Now?
If that's possible.
Well, have you ever been treated before for substance abuse?
Yes. There was a while back.
When?
So this 2019.
I don't consider that all that long ago, but where was that? What was the treatment?
This was in Texas,
Dallas, how long were you in treatment?
for many days.
It looks like you have a real prolific criminal history that I stuck my neck out on and granted you probation for. How many misdemeanor and felony convictions do you have?
I don't know.
What does that say? That you don't even know how many convictions you have?
Well, convictions I only have two. I have two felony convictions. That was,
You swear to God on that?
yes, I only have two that I was arrested for, but no convictions.
I'm looking at 3 convictions here. Theft of property in Hardin County in 2017. You were placed on 4 years deferred probation for that on July 8th, 19, and another theft of property from 2018 in Hardin County, Texas. On that same date, you were placed on deferred probation in 2019 for both of those. Those were revoked in 2023, and you received 9 months state jail in each of those 2.
Yes.
Plus, this case, you were convicted of this and sentenced to 10 years in prison, and that was suspended, but it's a conviction. So you've got 3 convictions, including this one. What about your misdemeanors on what kind of unauthorized use, kind of a theft, a related theft? Do you have any other theft convictions or anything like that? Yes, you do. You got in 2012, you committed theft in Ellis County, Texas. You were placed on 2 years deferred or unadjudicated probation for that theft in 2014. And the next year it was revoked and you were sentenced to 60 days in jail for that. Now, do you remember?
Yes, sir.
And then a misdemeanor of assault causing bodily injury to family. That was in 2015. You were placed on 12 months deferred or unadjudicated probation in 2016 for that. It does not show that that was revoked. So you must have served that out properly. Then you've got a failure to identify in Tarrant County. In 2015, you were sentenced to 7 days in jail. And let's go up to 2017 in Hardin County, 2 thefts of property. In February of 2017, in the next month, you pleaded guilty and were sentenced to 40 days in jail on each of those 2. You remember those now?
The only ones I remember is the ones I went to state jail for. So
Well, it's too bad you don't remember, but the computer remembers. And then we round out the field with failure to identify. In 2019, you were placed on 1 year probation, adjudicated probation. That was revoked and you were sentenced to 88 days in jail. That was out of Hardin County. Failure to identify, 30 days in jail in 2023. And resisting arrest in 2024, you get 44 days in jail, and those were here in Jefferson County, Texas. So I'm looking at 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 convictions in courts of record, including 3 felonies. And here we are. What's state say?
Your Honor, the state, based on the defendant's criminal history, he'd been given a chance before on probation. Obviously, he knew what he was supposed to do on this, and he didn't. He's got 3 new offenses while he's on probation. testing positive for cocaine. He's not reporting. Just about everything you can to violate his probation. The state believes the defendant will not be successful if continued on probation. We're asking for 6 years TDC.
Anything else?
No, sir, I believe. Bring me more.
Did you, Mr. Gill, this is your life. What do you want to say? Anything else you want to add? You got to fix all of this. You got to start. It's in the record. So every time you commit another offense, it's piled on by these others things. These others add to the weight, and the law says it does. That's why you have to make the right choices from here on anyway. But it's just going to get more severe for you. Was there any restitution on that?
No, Your Honor.
No. Go ahead. Anything else? Nothing?
Well, Your Honor, it all comes back to being addicted.
Yes, sir.
So I can't blame nobody but myself, but being an addict is the hardest thing.
Yes, sir.
And I apologize to you, to my family, to everybody that I've hurt because of my addiction, but I apologize.
What do you intend to do about it, though?
So
Here in this case, we worked with him on a substance abuse issue, didn't we?
So he was supposed to go to Franklin House, check us up every 30 days. He never went.
Okay. So we tried to help you on that, but at the end of the day, you've got to pull your own weight.
Yes.
You know, it's up to you to make the choice, and it's you to walk the walk.
Mhm.
We can only open the door of opportunity. You've got to walk through it, which you didn't do.
yes.
But this will pass. This isn't one of those cases that that whatever I sentence you on, you're going to be serving a long time. I wouldn't want to serve one day, but you'll get out, and then it's up to you to decide what direction you head in.
Yes.
And there are a lot of centers, placements that can help you, but it's got to be your choice. You made the bad choices that put you into this. You can just as easily make the right choices. It's climbing a mountain a little bit, but it's your choice,
Yes.
and you got free will. Fix it, because you seem sincere about it.
Yes.
But you've got to just don't talk the talk, walk the walk that it takes to do the right thing and get it done. Fix that. At the end of the day, other people aren't going to be able to do it for you. Yes, we'll make it available. It's available, but you've got to do the effort, the heavy lifting, like all of us do when we make mistakes, to fix them.
Yes.
I'm going to find that there is sufficient evidence supporting this first amended motion to revoke it by preponderance of the evidence or greater. As allegation 8 has been proven true, as the defendant is knowingly, voluntarily admitted, and to a violation of probation, failing to ID as a fugitive with intent to give false information. And that is enough to grant this motion to revoke probation. Thus, your probation is hereby revoked, and you are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 5 years, which is half of what you were sentenced to. How much credit does he have?
First branch, I've given about 90 days. Going back.
You're going to be given credit for all time you have served in accordance with this. We'll figure out what it is, but this is not one of those cases where you are looking at serving half time, but there will be some time that you're going to have to serve before you are released. And hopefully the prison has opportunities available inside for people with substance abuse. They're supposed to. I understand they say they do. Take advantage of them when you can. So good luck to you. And so, and we need his thumbprint one final time. And Quinette Henson, please. And Quinette Henson. And Ashley McKinney, that's,
She's out here.
25 CR 125. We call John James Loring, and that's you,
Yes, sir.
with Mr. Dusler, your attorney and the state's attorney. And what are we going to do today?
Judge, this is his first appearance that I met with him. He tells me that he's in the process of talking to Buddy Reynolds about hiring him So the court could give him 4 weeks, I think, if he get the close.
You are, just to make sure that you understand fully, you are charged with the state jail felony of theft of property here in paragraph 1. And that would be a state jail felony normally, carrying with it up to 2 years in the state jail, but you have 3 prior felony convictions out of, oh, there's another page. 4 listed here in the indictment, 2 on October 28th, 2009, out of burglaries of habitations out of Hardin County District Court. Thereafter, those were final. It is alleged in paragraph 3 of page 2 that you committed the felony of burglary of a habitation and were convicted in district court in 2014 in clause number 20272. After that became final, you committed the felony of burglary of a habitation and were convicted another burglary and convicted of that one in the 260th District Court of Orange County, Texas. So it's my understanding the way this is pleaded, if all of this was true, you were looking at a state jail felony, but it is punished as though it were a second degree felon. So you were looking at no less than 2, no more than 20 years confinement in prison, and a fine up to $10,000 can be assessed. You understand what you're looking at?
Yes, sir.
All right, the court has looked at this probable cause. What is the bond in this case?
It's 10,000.
2,000. Looking at a public safety report that is dated February 11th of this year. Are you appointed on this?
Yes, sir. This is the first time, you know.
So your bond is $10,000? Is that what it is?
Yes, sir.
The court is going to modify the bond in this case because the court does not trust you with your prolific criminal history. I want you to be on home confinement. You have to have a GPS device on you by the end of this day. And I want to, so I'll know where you are at all times. I don't trust you in this, looking at all of this. This is terrible.
So-
No, I'm speaking.
Yes, sir.
You have so many convictions here.
Yes.
And these just aren't burglaries of anything. These are burglaries of people's homes over and over and over and over again. And the probable cause affidavit here alleges you took somebody's credit card and misused it.
It was given to me.
You know what? This is not a debate. It's what the probable cause, and you can, the grand jury indicted you based upon these facts. You're presumed innocent, but there is probable cause to believe you committed this crime based upon these facts. Okay. Here's my favorite part. In the probable cause, you told the victim here, by the way, it was $8,000, over $8,000 in charges. Boy, borrowed it for $8,000. I've never heard of such a thing. Who would trust you in for a dime? I wouldn't give you a quarter of mine to hold. I wouldn't trust it. And what did you say here? You would pay the funds back according to this probable cause, but you never did,
Yes, sir.
which is what the probable cause states under oath. That is, when did you pay these people?
I started paying them on May.
No, when did you pay it back? You said you paid it back.
Oh.
When did you pay it back?
I was making payments with them.
You haven't paid it back, have you?
Not the
Completely?
full amount, no.
See,
No, sir.
you're trying to take my wallet right in front of me.
No, sir.
Yes, I said, did you pay it? You said I paid it back. You
Oh,
haven't
no, sir,
paid
not the
it.
whole amount, no, sir.
Do I have to cross-examine you to get the truth out? This is
No, sir,
terrible.
I was making payments with them. Yes, sir.
Mhm, yeah, but you are certified thief, all these convictions. And then you come up into here, I should have put you under oath because you can't even be straightforward with me right now. You're hedging in your statements. I got to correct you to get the right information. Good luck, because all of this is admissible, which the jury can consider in evaluating your credibility at a trial. It doesn't take 6 convictions of burglaries to convince anybody that you are a dangerous person and not an honest person. And here you are, charged with that. Again, probable cause to believe that that happened. All right. At the end of the day, you're at home confinement. You have a GPS device. You don't leave home except for the following things: for a medical need, to get food, to go to and from work. And those are the most direct routes possible. You have to have that by the end of the day. If I don't learn that you have it on you by the end of the day, a warrant will be issued for your arrest, and you will have no bond. You will sit that out until we get around to getting this case done. I'm considering raising your bond anyway, just for the way you handled yourself and not being forthright. Your bond ought to be 6 figures, what it ought to be. You think your criminal history and a new charge aren't worthy of that? There's a way to fix all of this, but you should have fixed it 6 convictions ago. Back to you, John.
Buddy Reynolds is representing him on a misdemeanor. He's working on hiring him. So he's trying to get money together to get Buddy hired. So we're asking 4 weeks.
Huh?
He's asking for 4 weeks.
You don't get it. You got 2 weeks. That's all. That's all you're going to get with me. I don't trust you at all. From what you say to me and your prolific criminal history. We'll see you back in 2 weeks. Get in, reset it. All right. Anything else, Don?
Yes, sir.
Ashley McKinney?
He's also in custody. Say.
Hey,
Is there some probation orders for Monday? We just need to signature on
I
them.
didn't, and I don't have anything. I didn't get anything from you.
That's all.
Well,
You're saying there's nothing? Yeah.
you actually do the meeting. Heard y'all got a new director.
That's what I heard too.
There's a new director coming in town.
Yes, sir.
Well, we're gonna, it's Jerry,
But
but we're gonna welcome Peggy. Okay, Pat Calhoun?
Yes,
Is that
sir.
you, sir? And we call, cause number 20-34315, the state of Texas versus Chad Allen Calhoun, here with Mr. Dusler, your attorney on the state's attorney. There's a motion to revoke unadjudicated probation that is on file as of April 3rd, 2025. Are we going to proceed on that?
Yes, sir.
And Mr. Calhoun, raise your right hand. Do you solemnly swear or affirm that any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lawyer. In summary, sir, this motion alleges that on December 16th, 2021, in this court, you were placed on 5 years deferred or unadjudicated probation for the state jail felony of burglary of a building. Is all of that true?
So, now one, two, everyone.
One, states you provided a urine sample on or about February 25th, 2025, which showed the presence of methamphetamines and amphetamine in your system. And that was in violation of number 10 of your probation order, which is do not use or possess any drug. And is that allegation true and correct as it is alleged?
It is very so.
Are you pleading true and correct voluntarily?
Yes,
And
sir.
because it is true.
Yes, sir.
Do you understand that a plea of true to one or more violations of probation, a voluntary and knowingly made plea, that's enough to grant the motion to revoke probation. Your probation can be revoked. You can now be found guilty and you can be sentenced up to 2 years in the state jail. Knowing that, do you insist on pleading true?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true.
Yes, sir. Very much.
Okay. Let's see. Yes, sir. Agreement has been reached here where you would be revoked, found guilty, sentenced to 1 year in the state jail. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Show you what's marked here, States Exhibit 1. Did you sign that document voluntarily? Understand it, discuss it with your attorney or the
Yes, sir, I
copy
did.
of the court?
Yeah.
States Exhibit 1 tendered into evidence without objection admitted. This states that all the parties, including you, understand that if I follow this agreement, you have no right of appeal. I'm going to do that. Let me ask one other thing. This is something I've noticed. Here, I guess it's under the order that states reimbursement fees. Those are probation fees. Is that what that is? That's what I've never noticed it before. Fees. That's not restitution.
No, sir.
Okay. In the deferral.
Can you show me? Oh,
It's entitled reimbursement fee / supervision fee, Judge.
okay. I'm not familiar with it on the judgment, maybe if I saw the probation.
But it's not restitution.
No, sir. There is no recipe for this.
I'm going to follow this agreement. If nothing further, I'm going to find, sir, you are pleading true voluntarily to a violation of your probation. You are doing that. You understand and appreciate the consequences of pleading true. That is enough to grant this motion to revoke probation. Your probation can now be revoked. I hereby revoke your unadjudicated or deferred probation that you have been on. And this motion is granted. Earlier in this case, you pleaded guilty voluntarily to the state jail felony burglary of a building. You were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in the hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of the state jail felony of burglary of a building. I am following this agreement. You are hereby sentenced to confinement in the state jail for 1 year. You will be given credit, of course, for all time you have served in accordance with that charge.
Yes, sir.
Do you understand what has happened today, sir?
Yes, sir. I do.
Judge, before you pass that aside, I've double checked. There is a restitution amount on this. It is $5,000, and I know you're not on that, what your typical rulings are. And I wanted to clarify my mistake.
Okay, maybe that was something, I don't know. But here in the probation order, there is restitution is owed the states in the amount of $5,000. Was anything paid on that?
He paid $572.
572?
Yes, sir.
So it's 572 less of,
His balance is $4,427
$4428.
on restitution.
all right, restitution is hereby ordered in the amount of $4,428. That will go to the complainant in the indictment, Rodney Gravett. Do you understand what has happened today,
That
sir?
part, I would like you to explain, please, sir.
Huh?
That part, I could use a little I'd like to know what that means, sir, please.
That means that you still owe $4,428.
Yes,
It's in the judgment. And
It won't cost you any more time in jail.
yes, sir. Thank you.
But it will cost you the money.
Yes, sir.
somebody can file a civil suit now
Thank you.
against you, and that would be and if they get the judgment, which is normally just pro forma,
Yeah.
it shows up on things that when you try to purchase a home or get credit,
Business
that can be used against you. But also, it was determined that was the loss, and you're getting a deal out of this. At the end of the day, that's half of what you could get, and it's at the end of the day, it's up to you. But the right thing to do is to pay people back.
Yes, sir. Very much so.
That's the right thing, and
Thank you.
maybe your conscience bothers you. I hope most people, and you'll do something about it and fix that.
Yes, sir.
That would be the right thing to do always, but that's your soul,
Yes, sir.
not mine.
Thank you.
Also, anything else?
No, sir.
That is all. Thank you.
Need your right thumb,
Yep,
sir.
we need your right thumb. Theodore Foley is going to be next. We call cause number 21-37943, the state of Texas versus Trayvon Brumfield. That's you?
Yes, sir.
With Mr. Dusler, your attorney and the state's attorney. Do you understand there is a first amended motion to revoke a probation that's been filed that we are going to be working on? Are you familiar with this? Did you have a chance to discuss this with your attorney? Is everybody ready to move forward?
Yes, sir.
Raise your right hand. Do you solemnly swear or affirm that any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? So lower your hand. This states that on April 4th, 2022, in this court, you were sentenced to 7 years in prison, and that was suspended and probated for 10 years for the third-degree felony of theft. Do you understand what this is charging you with? And this indictment was handed up back in 2021, and it states that you were placed on probation on or about June 3rd, 2021 in Jefferson County, Texas. You committed thefts of a value of over $30,000, but less than $150,000. And it's like dirt bikes. You understand? All right.
We can proceed. Judge counts 1, 3, 9, 10.
Let's just, 9. Okay. Was he an absconder?
Yes.
Oh, well, let's do 1 then. 1. Number 1 states you failed to report to the Jefferson County Probation Office on or about January 31st and May 9th of 2024, which was in violation of your probation order, which required you to regularly report. Is that true?
Yes.
And are you pleading true to that voluntarily, knowingly, intelligently, and because it is true as it is alleged? Do you understand that a knowing and voluntary plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation could be revoked and you could be sentenced from no less than 2 nor more than 7 years in prison. Do you understand? That's your gap we're looking at if you were revoked. So that's what you're facing, that range of punishment that I would be determining. If I follow, so do you understand by pleading true, that's what you're subject to? Knowing that, do you insist on pleading true to this allegation?
Yes.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Was he an absconder from May
Yes.
of 2024? Okay. How often was Mr. Brumfield to report?
Any alphabet.
No, but how often were you supposed to? Monthly or bi-monthly? Monthly. When was he placed into arrest? When did he get arrested?
He got arrested this year in May of this year.
Okay, so he was gone for a year.
Yes.
Oh,
He was in Carrollton and he had another charge and got arrested
where?
in Carrollton.
Dallas?
Denton County, that was in January of this year, Judge.
Okay. So you've been in custody since January somewhere, but from May of last year to January of this year, you should have been reporting and you didn't. Would that be 9 states you committed the offense of theft from person on or about January 11th, 2025 in Denton County, Texas, in violation of condition 1 of your probation order, which states you shall not commit a crime while on probation. Is that true?
Yes.
Are you pleading true to number 9 voluntarily, knowingly, intelligently, and because it is true as it is alleged? And again, the same thing, a voluntary and knowingly made plea of true to 1 or more violations of probation, that's enough to grant the motion to revoke probation. Your probation could be revoked and you could be sentenced to no less than 2 nor more than 7 years in prison. Knowing that, do you insist on pleading true?
Yes.
I find you are pleading true voluntarily and intelligently, and you understand and appreciate the consequences of pleading true. All right. I think that's going to be enough here. Let me just look at one thing. Was there any restitution here?
Yes, sir.
Because it's not in the judgment. It says restitution. There's nothing, restitution payable to, and it says not applicable. What the heck?
The motion reflects an amount of $4,752.50, Judge. That's supposed to be from condition 33.
Well, restitution was ordered by this court in the community supervision order, but it's not reflected in the judgment. Probably what happened it was to be determined later, probably, and we did the judgment immediately, and then this came after the judgment, I'll bet. But so what's the balance?
The balance right now is $3,312 restitution.
3,312
Yes.
and,
And 50 cents.
and 50? And that's to the complainant in this case?
Oh, yeah.
Yes, sir. Cowboy Schwartz, it's a name I remember.
Oh, no agreement. So go ahead, Mr. Dusler.
Well, it's obvious that he had problems in reporting, and he explained to me that he just had trouble getting transportation to do that, but he'll also address the court about it. We got the new charge up in Denton County that has not been disposed of yet. So whatever happens here, he's still got to take care of his business there.
What were we talking about? A theft of what? What's this?
I don't know the details of it. The ones there, I know it's pending, but he's admitted responsibility for it, and he intends to plead guilty to that. We've still got this restitution owed. He's a young man. He did not have a bad criminal history when we placed him on probation. The good news, I guess, is for a while he did report and he did make payments, and he has paid a significant portion of the restitution. And he's just asking the court to give him an opportunity to hold it in abeyance, let him continue on probation, and maybe he can finish this stuff up correctly. And you'll be able to tell the judge in just a minute. He'll let you talk.
And where's the other crime pending?
Denton County Judge.
Can anybody tell me anything about that?
I'm looking at a report that reflects that on January 11th of 2025, there's a report that he was involved in stealing from a Domino's delivery driver some pizzas and wings. Whenever they went to arrest him on January 24th, is when that subsequent offense arose about him evading. So the theft from a person is from a delivery driver, Judge.
The state feel is in the best interest of justice.
Back when he pled originally, I'd offered a cap of 7 years. I felt at that time the 7 years was warranted just because of the nature of his background and all. Your Honor determined that restitution was a good idea, and I feel like I always understand why you're moving that direction, Judge. Cowboy Sports was out. The money that we talked about behind his conduct and another individual's conduct coming over I can't remember that. I believe they came from a separate location because I don't remember these two defendants being locals. But they came here, they stole these dirt bikes, and they were caught in the process. They damaged that. That's where the restitution comes from. They were actually able to recover the items, but the damage that was resulted there. We had a probation offer on the other defendant, and I know that that was a factor as well, that the court determined to do that with Mr. Brumfield. So he was given really a third opportunity whenever he got this probation because he'd been in trouble before. And even though he was successful for a period of time, he's right back to committing the same kind of criminal conduct. He was an absconder, just failed to report to us for a period of 7 months before he starts committing criminal offenses in another jurisdiction. Now, I know that hasn't been resolved yet, but it sure doesn't look good. And I would recommend that the court not continue this man on probation. That I originally argued for 7 years. I'd have yet to see anything that warrants any consideration for some time less than that. So I'm going to stand by that.
From probation, anything you would like to?
Originally, when he went on probation, he was sent out to Louisiana. He was a resident of Louisiana, and he stayed out there for a little while. But then he wanted to return back to Dallas, where he said he wanted to live at. But when he got out there, that's when he stopped. And then they didn't accept him in Dallas just because he had some other ones in Louisiana that he had to do.
Thank you, Mr. Monroe. What do you have to say? If you want to say anything, Mr. Brumfield, this is your time. This is important. A very important point in your life.
Okay. I have the money to finish my application also right now.
What do you mean?
Well, right now, yesterday, when I sent my probation officer, Mr. Riley. Yesterday, I made my parents a call to associate office, and that's.
I don't hear you clearly.
Yesterday, whenever I see Mr. Robert, yesterday, Mr. Moore, yesterday,
Yeah.
I I had made my mother, my grandma call the social security office and tell the social security office how much my balance right now. And they told me that my balance is for $650. And I said, okay. And the only thing, the only thing I'm waiting for is to be released so I can get my money and get my card and get my probation also. And whenever I was reporting and everything,
Well, where's the money?
the social security office have it.
Okay,
I get the check.
here's, well, you're not gonna get released to go get it. That's not the way it happens, because we had experience like that before, trusting people, they leave, they never come back. We have to go find them again, and then when they're caught, it could be a while. But you're not gonna get released until this was resolved. But I want the money's paid. That would help you. But you're not going to get out to do that. You're going to have somebody on your behalf do it. If that's what you really want to do, which I'll give you the opportunity to do that. But you're not going to get released. You're going to have to work through somebody else, family, or somebody you can trust to get that. And if you get that resolved, I'm not going to just let you lollygag around on it. I mean, you just have days, not weeks, days to figure that out. But I want the restitution to victims. That makes a difference to me. That's one way to fix it. Plus, it benefits you in sentencing. I reward people who can do that, even at this stage. But you're not going to get released to do it, because we have a bad experience with that. And we're not going to go try to chase somebody again that you do it, but it's happened before, so somebody's ruined it for everybody else. So that's not what we learned a lesson. If you can get this restitution, I can give you 1 week. 1 week. If you can do it, get it done, get it over to probation. We'll come back, pick this hearing up over here, pick the hearing up where we've left off. And you and anyone else like this who pay the restitution back, the court rewards them. But it's still, you're going to pay it. You're going to pay the consequences here, but you can minimize it to some degree by paying the people back. Are you going to be able to do that?
So the only way I can pay my probation, unless I have to go to in front of the social security office.
I'm talking about the restitution.
Yes, sir. I have to go in front of social security because they don't want nobody else but me, because my grandma tried to go up there and instead of saying that
Okay.
they want me to go in front of them so I can.
Well, I'm not going to let you, I'm not going to, I can't release you for that. If you took off, it happened again. Y'all got to figure it out somehow.
I don't think he's going to be able to access those funds. They're going to make him do it in person. And I'm not even aware if funds exist, to be honest with you, just based on what he's saying.
Yeah. Well, you're not going to get released for it. You got to figure it out. If you can do it, I'll give you a week to try to get it done. Maybe your family can get the money together. And then when you're able to, you can go get them back that money when you are released sometime in the future. But no, you're not going to be able to amble about to make business arrangements and take care of business needs like this. Not when you've got an evading arrest. You've worn that freedom out while you're on my probation. But you think they might be able to help you in a week, your family?
No, sir, because they won't, because the social care, because whenever I went home in 2022, I had to go in front of the social care so I could get my full $28,000. I had to go in front of them.
Judge is asking you if your family, your mother and grandmother have the money otherwise. Could they get the money to pay your restitution and then you get out and get it from Social Security? Would they have the ability to come up with that kind of money?
The only thing they can try to come up with is my funds, so I can go home and try to get my money back. That's the only thing they have to try to do, so I get my money back.
No, I don't think it's going to happen realistically.
Okay.
let's, we can recess. I think we're kicking the can down the road, to be honest.
Yeah, what we're not calculating into this conversation is the fact that Denton County has a hold on them too, Judge.
Yeah, you wouldn't be able to get out anyway. He says they've got a hold. You wouldn't know that. He would.
He's got to resolve those, otherwise they're not going to just let them, like you say, amble around them.
Yeah, go ahead.
Oh, I don't have it hold because.
All right. No, it's not a debate.
No,
They know.
I know.
They know if they have information that says there's a hold from Denton County. And as long as that is, and he's good for his word, they know that, then they alert the authorities. Now, they may release that hold, but right now, he says, and he's good for his word, there's a hold on him out of that, on you out of that Denton County, which is a problem for you. You got to take care of that one way or the other after this. But once again, if there's a way you can get it paid through your family, the court would reward you. But that's not something that's realistic. We got to move forward today. And I can always, if the court sentences you to confinement, then I can always change that judgment within 30 days if something happens. I can bring you back and I can change it and for whatever you might be able to get done on your behalf. But you're going to be in custody if I sentence you. You're going to be in custody for the next 30 days.
I think that's appropriate. Go ahead and do that, and then we've got, you said 30 days to try to.
There are people on his behalf.
Yeah.
I know you're talking about Social Security, but I can't speak for him. But I know sometimes government agencies can be hard to deal with, but it's also been my experience that people over believe that too. Quite often the government authorities work with people a lot easier than they thought, or people on their behalf. If people on their behalf or close relatives who have proof and information of what they're doing and why they're doing, and it's in the best interest of justice, and they seem to work together when that can happen, but not always. Nothing further. I'm going to find there is sufficient evidence supporting this first amended motion to revoke probation to granted by a preponderance of the evidence or greater, as allegations 1 and 9 have been proven true. And did the state want to add anything else?
No, Your Honor, I've made my best argument.
And you're asking for
7 years.
And Mr. Duser is asking to continue you on probation in some way. Again, there is sufficient evidence supporting this first amended motion to revoke probation to granted by a preponderance of the evidence or greater, as allegations 1 and 9 of the first amended probation have been proven true, as you have pleaded true to those voluntarily, knowingly, intelligently, and appreciating and understanding the consequences of pleading true. Your probation is hereby revoked. You are hereby sentenced to confinement in the institutional divisions of the Texas Department of Criminal Justice to serve a term of 6 years. And restitution is ordered in the amount of $3,312.50 to the complainant in the indictment in this case. That will be placed in this judgment. And that's the finding of this court. If something can be done on restitution within 30 days, let me know. And we'll see what we can do about rewarding you somehow. Anything else? That is all. Thank you. Next is Mr. Calhoun, Chad Calhoun.